welcome to those of you attending and joining us. Sure, more will trickle in. Welcome to another session of the 69th Annual Utah State Historical Society Annual Conference. Just a reminder that this session, along with other sessions that we've had this week, and as well as some pre-recorded sessions that we've done for this conference, all of these are made available on our YouTube channel, and you can access that through our websites, history.utah.gov or ushs.utah.gov. So this afternoon session will run for an hour, till 1 p.m. Mountain Time. And the panelists have agreed to field some questions. So we encourage anyone listening to enter your questions into the Q&A box at the bottom of your Zoom screens. And then we're also going to try to get this going on Facebook Live. Again, it will be recorded and made available on YouTube. I want to thank, in particular, our sponsors of this conference, our sister agency, the Utah Division of Arts and Museums, our parent organization, the Utah Department of Cultural and Community Engagement, and then our partners, Utah Humanities, and especially highlight Utah Westerners, which I know Cannon is heavily involved with. And so thank you very much to our sponsors. We have a really interesting conversation today that I'm super interested in. It's titled Disparate Treatment of Non-LDS Defendants in Criminal Cases in Territorial Utah Probate Courts. And to chair this session, I'm going to turn it over to Ken Cannon, who is a practicing attorney and independent historian, longtime supporter and contributor to the Utah State Historical Society and the Utah Historical Quarterly. Lots more to say about Ken, but with that, Ken, I'm going to turn it over to you.
Thanks, Jed. So today's panel is very interesting. In Territorial Utah, local probate courts exercise unusually broad jurisdiction for a variety of reasons until the Poland Act of 1874 ended that. Congress ended that in 1874. Our speakers, Professor Jason Twede of Utah State University and Amy Berlin, a recent graduate of Utah State, addressed differential treatment of Mormons and non-Mormons as defendants in criminal trials in the probate courts of 8 rural Utah counties in this period. Jason Twede is an assistant professor of criminal justice at Utah State University. He received his PhD in criminal justice from the University of North Dakota. Earlier, he received a Juris Doctorate. He's one of those people we call a recovering lawyer, and worked as a prosecutor in Navajo County, Arizona. His research focuses on the history of criminal law and the criminal justice system. Amy Berlin graduated from Utah State University in spring of 2021. She received her Bachelor of Science in Sociology with an emphasis in criminal justice, a minor in psychology, and a certificate of law and area studies. Earlier, she also received an Associate of Science degree from Utah State with a major in criminal justice. I'm going to turn the time over to them. I think Jason will speak first, and then and Amy after, and then maybe they'll have some interaction together.
Thank you, Ken. Yeah, as was mentioned, please feel free to ask questions at any point during this. I do have the chat window open that I'll be looking at, as well as others. So if you have a question at any point, don't feel like you're interrupting us or anything like that. We're happy to address questions as they arise as we're doing this, or presenting our research on this. But as Ken had mentioned, what we looked at as part of this research was criminal cases in Territorial Utah prior to the Poland Act. So to give a little bit of history of, what time frame we're looking at, why we're looking at it, what the issue is. When we first established Utah, we weren't a state yet. And so the territory was under, as far as criminal cases went, territorial jurisdiction, which was federal jurisdiction. What that means is if you had a crime that arose in the Utah territory, you would take it to the territorial court, and the court was federal. It was overseen by the United States government. as such, the judge, prosecutor, all the officials in that court would have been appointed at the federal level by the President of the United States. So fairly early on, I believe it was 1851 when this initially occurred, Utah decided to give their probate courts, their local courts, for lack of a better term, criminal jurisdiction. In other words, the local courts that were not under the United States government were given the authority to hear and decide criminal cases. This continued from about 1851 to 1874 when the Poland Act was passed. Now, the Poland Act, without getting too much into the details of it, the Poland Act was an act in the United States Congress that sought to do away with the jurisdiction of these courts. Part of the concern, it seemed like, was they may have been used to prevent polygamy prosecutions from taking place at the time at a criminal level. But in addition to that, one of the issues raised in the congressional record was whether or not these courts were being fair to all citizens. Was there a bias that was favoring Mormon claimants, Mormon defendants in these courts? And there was some concern that that might be the case. Now, as part of the hearings that they had for the Poland Act, George Q. Cannon, who was an apostle in the LDS Church and was also a representative to the Congress for Utah at the time, did testify during those hearings. And he had, in response to that specific claim that the probate courts were favoring Mormon claimants, Mormon defendants, he cited some statistics. He said that he had 84 cases pulled from the Salt Lake probate court. And of those 84 cases, 59 of those were resolved in favor of non-Mormon claimants or non-Mormon defendants. Now, unfortunately, that's about the extent of what we get on the congressional record, is that statement. We don't know which cases were pulled, whether they were pulled randomly, whether that was all the cases for a certain time frame. We're not sure if those were cases between non-Mormon claimants and Mormon claimants, or whether they were just, whether we had some cases where both parties were not Mormon in there. So we don't have a clear picture from those statistics alone, whether or not there was actually fairness in the court system. So what we've got now then, so 74, the jurisdiction of those probate courts have been cut off, but that question still sort of lingers. Were those courts fair during the time? Were Mormons and non-Mormons treated similarly? There has been some prior research on this issue. It has been a while. It's not entirely recent research, but there are two articles in particular that tried to examine this claim, one in 1970, another in 1980, and they looked at a sample of Salt Lake County's probate court and then Utah County's probate court respectively to see if there was fairness in the way the court operated. Now, our research is a little bit different from those two. They looked holistically at the court, both civil cases and criminal cases, to see if there was fairness in both of those realms of the cases. We focused our research specifically on the criminal cases to see whether or not in the courts it appeared that Mormon defendants and non-Mormon defendants were treated fairly in terms of sentencing, in terms of the rate at which they were charged, things of that nature. So for our research, we're going to present what we found, and we are also going to reference a little bit of what those two prior articles found as well, just to show where they coincide, where there may be a little bit of difference in their findings and our findings, and try and explain why that might be the case. Okay. So that's really sort of the setup of what we're trying to do and why we looked into this. Now, for what we did, we focused not on the courts that had already been looked at. As I mentioned, prior research had looked at the Salt Lake County Probate Court to see if it acted fairly in terms of its treatment of Mormons and non-Mormons, and the same with Utah County. what we did is we looked at every other county we could find data for, to see whether in those counties Mormons and non-Mormons were treated fairly. As Ken had mentioned, we looked at 8 counties in particular, and let's see if I can remember all these off the top of my head. I believe we had Beaver, Box Elder, Iron, Juab, San Pete, Washington, and then I see Amy looking at the list. Which 2 did I forget there, Amy?
That would be Millard, Kane, and Davis.
Millard, Kane, and Davis. Okay. And if I remember right, when we looked through this, I should probably let Amy explain this part. Amy was the trooper on this. She went to the state archives, looked through all the court records available for these 8 counties, and essentially tabulated the data we needed from 8 counties worth of criminal court data, so that we could have our data set of, case outcomes, names of defendants, victims, etc. Amy, did you want to explain real quick take as much time as you need, but explain what it is that you did with the research end and gathering that data?
It basically just involved going through mostly microfiche foam, and there were occasionally actual books to go through that were fairly large for court records. And it was just going through and making sure if I found the prosecutor, which was kind of the information that was probably missing the most across the board, is they didn't outright stipulate who the prosecutor was on either side of the criminal cases, but finding the defendants, the victims, sometimes just the complainants who were sometimes complaining because they were the victim or on the behalf of a victim, and then finding out what the charges were and what the judgment was. And sometimes the records were a little incomplete. I mean, there were several times within the microfiche or the books, pages were very distinctly missing, or some were too damaged to be readable. But other than that, it was kind of hard to find sometimes the total value of what the judgment would be, because sometimes they would be postponed for trials at later dates, and then you wouldn't see it again in the information that we had. Or they would say that they were incarcerated, but they wouldn't tell you for how long. So some of it was a little not complete, but we basically gathered as much as we could to figure out how the values turned out.
Excellent, thank you. Yeah, we did try and gather what we could. I mean, you got to deal with what they kept as records back then and what still exists. So there were areas where there was missing data, and we noted that where it was missing, whether it be victim name, etc. But we gathered as much as was available. After Amy had done all of that, what I then did was take the names of the defendants and the victims that were listed in these criminal cases, and then I ran them through various databases to see, to verify whether they were, Mormon or not Mormon. There are a couple of pretty thorough databases and books out there through which you can do this. Perhaps the biggest one that we used was Susan Easton Black's 50-volume set of early Mormon pioneers, early Mormon members. We ran it through that. There are a couple of other fairly comprehensive sets. I think Pioneers and Prominent Men is a book at the time that details short biographical information about some of the early members of the time. We also went through the Mormon Biographical Encyclopedia 4-volume set to do that. We also were able to find, in some instances, the ward rosters for various wards in the different counties that we were looking at the Family History Library in Salt Lake. And so we also cross-checked all the names against the microfilm registers down there for the pertinent time periods. So in total, all these names we ran through 4 to 5 different databases to verify whether the names showed up in any capacity as being Mormon or on Mormon records at that point. And that's how we determined whether or not your defendants' victims were Mormon or not. They would not list that in the case data. That's not something that they were, listing, here is the defendant, they are Mormon, here is the victim, they are not. We had to go through and pair that up because that's not standard data that would be kept in a court case. So that is how we compiled all of this to figure out, okay, well, who was Mormon, who was not, and how were they treated. Let me share my screen here real quick. So we ran several different tests, statistical tests, to try and determine whether there was fairness or not. So let's do file, slideshow. There we are. Thank you. Okay. Is everybody able to see that? I'm hoping I shared that correctly. Okay, so one of the things we looked at first was just standard across the board conviction rates. Were Mormons and non-Mormons convicted at a similar clip when they went through the territorial probate courts? If you look here from all the counties we looked at, you can see that numbers of defendants found guilty, Mormon to non-Mormon, looks about the same, 109 to 103. That's pretty, statistically speaking, the same. It's when you look at the number of people acquitted, the not guilty, that number does shift. You see that there were nearly twice as many Mormon defendants as there were non-Mormon defendants that were found not guilty of the crimes charged for. So we have there at the end conviction percentage of all the cases where we had complete data for, right? If you were, for Mormons, 77% of their cases resulted in a conviction. For those defendants that were non-Mormon, 86%, so 9% more resulted in conviction. So there does appear to be some difference in the chances of being convicted that cut against non-Mormon defendants as far as criminal cases go. Now, what we did in addition to that, this next slide, what we did is we broke it down a little bit further. We wanted to look not just at the interaction, just straight across the board, were non-Mormons convicted more frequently than Mormons. What we wanted to do is bring in the status of the victim as well. In other words, was the victim Mormon or were they non-Mormon? We did this, there's similar research like this done in the criminal justice field for several different things. The one that comes to mind to me most readily is with the death penalty. You have several researchers look at the death penalty to decide, okay, well, are Black defendants more likely to receive the death penalty than white defendants? Doesn't matter whether the victim in those cases was white or Black or Hispanic or whatever race, ethnicity we are looking at. And you do see some increased disparity when you with the death penalty when you start looking at the race of the victim in addition to the race of the defendant. So we wanted to look at that here as well to see if there was any disparity when you took the membership status of the victim into account as well. In short, it appears as though there was some difference. If you look at this chart here, in particular, the second line down, you'll see if you had a Mormon defendant and a non-Mormon victim, the conviction percentage in those cases was only 67%, 2/3. So that is the lowest of all those. So in other words, if a Mormon victimized a non-Mormon in a crime, in those cases, the conviction percentage was the lowest. And if you look at the other category, a non-Mormon defendant versus a non-Mormon victim, that's the third line down, they were then the second lowest, 75% conviction rate. And then if you had, excuse me, if you had Mormons that were victimized, you can see that those conviction rates were a bit higher. So if you had a Mormon that was the defendant with a Mormon victim, 89%, and then if you had a non-Mormon defendant who had victimized a Mormon, that was the highest conviction rate by a bit there, 93%. So when we look at this, we can see even more disparity than from the previous statistic. It would seem that, based on this, if you as a victim were not Mormon, the chance that the person who perpetrated a crime against you being convicted, and I should say allegedly, right? We're assuming in all these cases that, all other facts being equal, but we look there, the percentages are lower for non-Mormon victims for conviction percentage, whereas if Mormons are victimized, the conviction rate is higher, in particular if the person who perpetrated the crime was not Mormon. So it does look like there is some interplay there when we take the victim status into consideration. Any questions on either of those before I move into the next chunk of this? All right. So the next thing we looked at beyond conviction rates were the punishment, the sentence that defendants received. Now, not all, it becomes difficult in the criminal justice arena sometimes to compare punishments to see whether they are fair or not, just because not all punishments are going to be of like kind. Common punishments are going to include a fine and incarceration, and they can certainly include other things. Not so much back during this time period, but if we look today, counseling, community service hours, things of that nature get ordered as a sentence. And so the question becomes, in particular, when we're looking at fines and incarceration, how do you compare those two? Can you compare those two? In short, we chose not to try. We didn't want to try and say how many dollars equaled how many years of incarceration. So what we did is we took any case that included a fine, where a fine was ordered, and compared those. And then the next slide, the next chart I'll show you is any case where there was incarceration ordered, and we compared those to see within that what the difference was. So if we look here, the average fine amount that was ordered for Mormon versus non-Mormon defendants, you do see that for non-Mormons, the average fine that they received was roughly just shy of $20 more on average than the fines ordered for Mormon defendants. So there does appear to be that difference there. And if you look there, the overall average, include everyone together, is about $36. So it was a good bit higher than the average. When we look at the incarceration, we do see a similar trend. However, well, I'll get into the statistical end of it here. But if we look, non-Mormons that did receive a prison sentence received a little over a year more on average than Mormon defendants did. Now, I've listed on all these charts, you have the P, the probability down there at the end. For this particular one, the other three charts, the statistical likelihood that pertained to the rest of the cases statewide appears to be pretty high. This one, not so much, probably in part, at least, due to the low number of cases in general where someone was ordered to serve a term of incarceration. If you see, there's only 28 cases out of the, I think it was 338 cases total that we were able to find. Only 28 included some amount of incarceration as part of a sentence. So yes, there does appear to be more on average that non-Mormon defendants were ordered to serve. But without finding some more cases, it'd be hard to say, with statistical certainty, right, that this would pertain statewide. One thing that is worth noting, though, that is of interest, you look just at the number of cases here of defendants receiving some sort of a prison sentence. You'll see that non-Mormons received 21 of them received a prison sentence, where Mormon defendants only 7 did. So there were 3 times as many non-Mormons who got incarceration ordered as a term of their sentence compared to Mormon defendants, which in and of itself does seem to be, a good bit more. It would seem to cut against, it would seem to be cutting against non-Mormon defendants as far as fairness goes. So the last thing that we looked at is just straight numbers across the board. If you look at the number of people charged with a crime, not whether they were guilty or not what their sentence was, but just whether they were charged or not, you do get to see some difference as well. Now, the three I've got here, Powell and Gee are the authors of the two prior studies that looked into fairness in the probate courts when it came to criminal cases. They also looked at civil, but these numbers that I included here are just in terms of criminal cases. If you look at ours, we found 338 cases. 13 of those cases, there was not information for the defendant. Either they put them under an alias or something like that. And so we were not able to determine one way or another whether they were Mormon or not, because the name provided was not their actual name. So of the 325 cases where there was a definite name that we could cross-check that on, there were 149 of the people charged were not Mormon, or if we're looking at the percentage, that's the percentage of non-Mormons being charged. So 46% of all the criminal defendants named were not Mormon. It's fairly consistent with the findings that Gee had found in her research in 1980. In hers, she looked at 156 cases total, and 41% of those were not Mormon. Powell, that was research done back in 1970. He looked at 38 criminal cases, and of those, 66% were not Mormon. So when we look at that, 40%, 46% in ours in particular sounds not too far off from 50%. And, at first blush, we might say, well, that sounds about even. But when we compare this relative to the population representation of non-Mormons in Utah at the time, it is a lot more skewed. If we look around this time frame, estimates that I've been able to look at said, roughly 20% of the population would have been non-Mormon. So when your population is 20% non-Mormon, but in the criminal justice system, they make up 46% of the cases, it appears they are being charged with crimes at twice the rate of their population representation. This is something you will see, to compare it to other modern crime trends, right? We see this when we're looking at racial discrimination in the criminal justice system as well. When you look at the rate at which, say, Black defendants, Hispanic defendants are charged relative to their population representation, it is higher in many areas, which then leads to compound problems down the road. If you're exposed at that initial stage in the criminal justice system more frequently up front, then you rack up a criminal record quicker. That can have compound effects down the road, which then leads to disparities you see in incarceration of minorities at a disproportionate rate down the road. So it is of note here to just look at the rate at which people are being charged, not necessarily even convicted, but at what rate are they having more contact with the courts and being brought into the system? And it would appear that they are being disproportionately charged with crimes relative to their population representation. That was something that Gee had mentioned in her research as well, that she had found, was that they non-members were being charged at a disproportionate rate when it came to criminal cases. But in a nutshell, that is our data. Just those points there. I can bring any of those up if anybody wants to look at that. There we are.
We have had several questions pop up.
I apologize. When I was sharing the screen, my chat thing went down, so I apologize for not catching that. Thank you, Amy. Let me look at some of these here. let me start at the top here with the questions. Were any of these fines in addition to incarceration? Yes, there were only a couple cases where that had occurred, where someone would get a term of incarceration and a fine. Like I said, I don't have the number off the top of my head, but I do remember there being a couple of those cases, but that was the exception, not the rule. There were some where it was compound. Can I give some examples of examples of some of the crimes? Yeah, I can throw out some. Amy, you went through the criminal stuff too. You might have a more broad picture of this.
So there was typical like murder to, one of the 3 degrees, assault and battery, assault, rape, larceny, some of the stuff that we see a lot of nowadays. And there are some that are definitely more reminiscent of the times, like profanity, misusing the name of God. Some cases had just seduction, which were a little like you could kind of take that either way. And sometimes it tended to be more on the side of a husband charging another man for seduction of his wife. And then we also had some replevin cases, which were kind of like where you would almost mistake a crime occurring. Like if someone's livestock got out of their farm and it took a while for them to realize how many they were missing, and someone else found said livestock and just was like, great, these are mine now, without knowing they belonged to someone else. A lot of those cases were under the label of replevin. And there were some that were more of the time of selling weapons or ammunition or trading with Native Americans of the area. And sometimes they would charge the people that traded with them. There were, I think, maybe 3 to 5 cases where the Native American themselves was held in court for charges to that manner as well. And there were cases of like gambling, riots, and that's kind of the broad aspect of the different kinds of crimes.
Thank you. Yeah, I did want to mention in relation to replevin cases, those were civil causes of action. And so we didn't include the replevin cases in the data that I had just shown you on the tables. We tried, we analyzed those different, what we called crime adjacent cases that are charged as a civil matter, but could be charged as a criminal matter, theoretically, whether that be replevin, returned by taken property, which could be charged as a theft or larceny at the time. Assault and battery, there were a couple of those that were charged civilly as opposed to criminally. Again, those could be charged criminally. We analyzed those separate, so those weren't included in that data. We looked at that separate, but as far as the ones included, what Amy said, that was essentially what we covered. Larceny was a large one. A lot of it was theft stuff. Regulatory offenses, as she mentioned, like, I think there's various regulatory offenses as to selling weapons and other things to the Native Americans, things like that. There were some regulatory offenses, gambling offenses, things like that. So those were some of the things that we did look at. So it covered quite the gamut, but I will say this, there were some homicide cases, but they weren't extremely frequent. There was a couple in there. So next chunk of questions here.
I will add to that really quick. Going through the different counties, I will say I saw the highest number of murder cases occur in Sanpete County. Like there was a lot of murder in that county for whatever reason.
So yeah, that maybe not the safest place to be then, I guess, at the time comparatively, but yeah, so we do see that. So this question right here on case strength, were we able to evaluate case strength? We did not, and I will say this, some cases you might be able to, but the vast majority of these cases, when we looked them up, may have been about a paragraph long, maybe a page as far as the data provided. It has a lot of, what we sometimes refer to as legalese, right? On this day in this jurisdiction on this date, the defendant aforesaid did this, right? And so they essentially, it just got to the down and dirty facts for a lot of the, or procedural facts, not the actual facts of the case for a lot of the cases that we looked at. So it just said this person was charged with this crime on this date. We submitted it to the jury found them guilty, here's their sentence. So for the vast majority of cases, even had we wanted to dig into it, case strength wouldn't have been something we could have looked into because the facts of the case simply were not included. There were some cases where there were facts included, but not a significant amount. So we did not do that in this analysis to gauge case strength. So the next question there, did the same defendant appear in more than one case? Absolutely. There were some defendants that were very prolific, and they showed up several times within the county court records, both as a defendant in some cases, then as a victim in another. So we did have a lot of repeaters. And then were there differences in the rates of charging and conviction between the various counties? I want to make sure I understand that question correctly. So there were certainly counties that had a whole lot more criminal cases included than other counties. With that question, are we looking at whether there was just a difference in the charging rate between counties and then a difference between the conviction rate between counties? Or are we asking the difference between those rates per county, if that makes sense? Okay, different in the conviction rates. So when it comes to the conviction rate, I don't know that there was a whole lot of difference. It's difficult to say with some of these counties. For example, there were certain counties that had a very limited number of cases that were even charged. So I can tell you, like at the charging rate, there definitely was a difference just because of the number of cases that did or did not show up. For example, I believe in Iron County, there was only 4 criminal cases we were able to find out of all of these court records, right? So essentially what Amy went through and did, we have just the probate court records in general. That was every single case that was heard by the probate court at the time, whether it be a civil case, a divorce, settling of an estate, or a crime. And so you just had to go through and find where the crimes were listed in there. So the records tended to be long, but finding actual crimes in there, Iron County, I think only had like 4. And then you compare that to, say, Box Elder County that had well over 100. Yeah, their rates of charging stuff, or at least recording what they did, was drastically different. As far as their actual conviction rates on the tail end of that, whether one county was more likely to convict versus another, I'm trying to remember the breakdown on that. The short of it is, it's difficult to tell just because some counties did charge so low. It's hard to say where that, whether it was representative of the whole. Statistically speaking, like when you only have 4 cases, yeah, on all 4 of those, I think, if I'm remembering right on this, I think none of them were found guilty, or at least there was no final disposition recorded, so we're unaware on that. As far as the Mormon, non-Mormon breakdown and conviction, I know we looked at a couple of the bigger ones in particular, Box Elder, Washington, San Pete, to see if there was a difference in the Mormon, non-Mormon breakdown. And from what I recall, it didn't appear to. I mean, there was some difference, but not so much that we'd say, oh, well, in this county, it appeared fair, this one, it didn't. The numbers seem to pertain, at least in the bigger counties that we looked, or when I say bigger counties, the counties with more convictions, the ones where the data set was bigger. So San Pete, Washington, Box Elder. The other 5 counties that we looked at, the numbers were relatively small. And so the difference, I'll be honest, I can't remember off the top of my head whether there was that much a difference in those counties, just because even if we were to run it, this test that we give out, because there's a small number, our statistical software yells at us for not having enough cases, is essentially what it is. So that's a long way of saying I don't know for certain per the counties with the smaller data, but for the ones with the larger data sets, San Pete, Washington, and Box Elder, that breakdown was roughly the same.
And
Excellent.
to add
yes.
to the question about the strength of cases, the ones where we had more information about what occurred throughout the course of a case tended to be more so in the counties that actually had minutes along with record books, because record books like Jason said, are just straight facts. Like, this is the charge, this is the defendant, this is the victim, you know, this is the judgment. Whereas the minutes are more a little bit of like a play-by-play, and a lot of it, unfortunately, in the very beginning is wasted on like so-and-so arrived at such time, and until they were all grouped together. But the bigger cases, minutes were where we found a lot more detailed information about, you know, who the witnesses were, who they were witnesses for, whether it was the defendant or the other side. And so that was a little bit different. We didn't have a lot of counties that had a lot of records for minutes. They were either very small or just didn't have any at all.
Jason and Amy, why don't you, questions have been great. I've got a few minutes of comments. Why don't you create a deck, and I can give some general comments in response to.
No, I think that ties up what we had there. So sorry there, my screen blacked out for a second. That's why I ended up closing the screen on myself for a second so I could see everybody again. But yeah, that really sums it up. So Ken, yeah, if you want to take it from there.
No, and I really appreciate it. I think the questions are really interesting, and my comments go to a little bit different kinds of questions. And so I just wanted to get to this. The interesting thing about probate courts, as Jason and Amy have said, in Utah, in Territorial Utah, is that they had general jurisdiction. I mean, there was a minor court. It was presided over by someone who was not a lawyer, had no legal background. It was usually Mormon bishops or other Mormon leaders, and yet they had no limit with respect to criminal or civil jurisdiction. They were hearing first-degree murder, what would amount to first-degree murder cases. They could have heard large commercial law questions. And so when you have a system like that, one of the really interesting questions is, and I'd like to ask you this, did you ever find an appeal? Did you ever find any, I mean, was there the right to appeal from a probate court decision? And if so, to what court?
I will say I didn't find any appeals within the court record books or the minutes.
I'm sorry, I've got dogs. If you've got a murder case, you have a murder conviction, you have no appeal right, or if no appeal is taken, that's a red flag of a really serious problem with the jurisdictional issues in the courts. Because what should have happened is that there should have been an appeal right to the territorial courts. I mean, you couldn't have gone to from a probate court to a bishop's court. So it's an interesting question that I don't know. That it'd be interesting. It would be nice to know more of how this off. Just a second. Sorry, got someone outside that my dog wants to bark at. One of my dogs wants to bark at. The interesting thing about your data is that it's there's not a whole bunch of it, and there certainly seems to be some bias against non-Mormons, and yet. If you look at the overall figures, the majority of all defendants were convicted. I mean, it wasn't a matter where, a few Mormons got convicted and all the non-Mormons got convicted. Most of both groups were convicted, which is an interesting kind of thing. I can see in the criminal side, who was prosecuting these? Were these just county prosecutors? Do we know? Do you have any information about who was prosecuting these cases?
If we're looking at what was included in the data, there were some counties that were better than others that at indicating where there was a prosecutor. If we go by statute, there should have been an appointed government official, a prosecutor, to oversee these cases.
A local official.
Yeah. So whether or not they listed the name of that person in the case was entirely different matter, but theoretically they should have been overseen by them, and very well may have been. It's just the records were hit and miss as to whether they mentioned their name.
Understand, and my guess, if it's under the control of the legislatures, would have been with respect to local officials. There's going to be a high proportion of these people are going to be LDS officials, and you can see them bringing criminal charges against anyone, against everybody. At a certain level, more interesting to me would be their civil jurisdiction why would a non-Mormon go to a local probate court presided over a Mormon bishop? And I don't know why anyone would ever choose that, unless there's easier access, you get it in a timely manner, it's not a very big issue. Interesting questions that I'd like to know more about probate courts. I don't know if anybody's ever really asked. There are some really interesting cases. I mean, there's a famous, there's going to be an article in Utah Historical Quarterly next year written by Laurel Thatcher Ulrich about a murder case in Iron County and Cedar City in the 1860s, which was heard by a probate judge, which is a little bit bizarre. You know, it's interesting. The Poland Act in 1874. I'm doing a biography of George Buchanan, and the really interesting thing is between 1861, when the Moral Anti-Polygamy Act was enacted, and in 1874, when the Poland Act removed general jurisdiction from local probate courts, there are no Mormon statutes enacted because he effectively blocked most of them. The Poland Act, he wasn't able to. An interesting thing about the Poland Act is after I found a case which was assault with a deadly weapon in one of my seduction cases that I found, that was heard by a bishop in a local police court. It wasn't a probate court. They started using the local police courts after the Poland Act was enacted, which is just another attempt to circumvent the territorial courts, which I think actually have a mixed. There's a really interesting murder case in 1850s, where Judge Snow, who's one of the federal judges, says, sometimes I sit as a territorial court, sometimes I sit as a federal court. And I think the territorial courts in Utah actually had mixed jurisdiction, where one was a lot more of a local kind of thing, and one was actually a federal, more like a federal court today. And that's an interesting thing that somebody ought to look at. The final thing is looking at courts in Utah overall. You know, on the one hand, your data is very interesting to suggest that non-Mormons didn't get as fair a shake in the probate courts. At the same time, Judge James McKean hauled Brigham Young into federal court, said this isn't U.S. against Brigham Young, this is federal authority versus polygamic theocracy. And he pulled juries that were entirely non-Mormon. He wouldn't have a Mormon juror in his court. And so really interestingly, you know, that I wonder if some of the probate court actions could have been reactionary to the federal judges in the territorial court. In 1886, George Buchanan was famously arrested in disguise in Nevada. Was brought back by train. He jumped off the back of the train up by Promontory Point. He came in. He injured himself. He came in. He was charged with 2 misdemeanor unlawful cohabitation charges, which carried a maximum charge of 3 months in jail and $300 fine. He was released on bail of $45,000, which is the equivalent today of about $1.2 million, on account of 2 misdemeanor claims. And of course, he jumped bail. He also famously jumped bail. And so the overall, you know, we kind of divide this into the probate courts and the territorial courts. Probate judges appointed by local officials, probably Utah State Legislature. Territorial courts appointed through the federal process, and their differential treatment. And what somebody needs to do is to kind of find a way to integrate and look at both of the courts in the same way. I mean, you've got concurrent jurisdiction courts, which is a bizarre thing. And you could have a really interesting jurisdictional question. For example, you could have had somebody tried by a jury in the probate court and then say, no, I want to be tried again. Well, guess what? Under U.S. law, no jury can review the factual findings of another jury. It's got to be by an appellate judge, not a jury. You can't try somebody twice in different courts with juries for the same charge. So really fascinating jurisdictional issues that I hope you can kind of delve into as well. And you know, good stuff. And I poked around the territorial court records enough to know that they are a nightmare, as Amy, I'm sure you found out, and Jason both. They're a nightmare to try to navigate, to find stuff. I wrote a long time about this 1857 case, and I just republished the article that I wrote 40 years ago because I found a lot of new stuff. So keep looking too, because you may find more that you didn't know was there. A really good job, and I appreciate this. And I have said my piece, and now I'm happy to have other people ask more questions if you'd like to.
I will say I was very grateful for court record keepers who had really good penmanship,
Yeah,
because the ones that were like, they must have been doctors because it was so bad. It was so frustrating to have to zoom into something to try and notate, like, if it was a certain kind of cursive that could be like between 1 or 3 letters. So the ones that had really clear penmanship, I was so grateful for.
absolutely.
I did see one other question in the chat, and I think Amy addressed it real quick, but as far as whether a jury was selected or whether these were judge decisions, just real quick, as far as how that would break down, as far as guilt or innocence went, when we had guilty, not guilty, that was just across the board. Was their guilt found, whether it be because they admitted to it or whether they were found guilty, or not guilty being whether or not they were acquitted at trial, case dismissed for whatever reason, etc. So when we're looking at whether there's a jury, the only time a jury would have come into play is if the case actually went to trial. And in there, it's only guilt or innocence, not the actual sentence received, that would have had any impact. So there were some cases with juries, as Amy had mentioned, murder cases in particular. A lot of the, I mean, I hate to call them routine crimes, but you know, your larcenies and your regulatory offenses like gambling and stuff like that generally did not. But there were some that did. And to that end, some cases were good at listing who those jurors were. And we could certainly go through and do the same analysis that we did as far as, well, did these tend to be juries composed of Mormons or not Mormons? We did not do that in this case, but some of the, you know, in those cases where that did exist, it could be done. One last thing I did want to add, because I meant to add this back when I was talking about the various types of sentencing. Out of all the cases we looked at, there were 2 cases that involved a sentence of execution in murder cases. Both of those were Mormon defendants. So I will say this, when it came to, you know, was there disparity, you know, between Mormons and non-Mormons as far as sentencing goes? It appeared when you looked at the lighter type of sentencing, fines in particular, there did appear to be a more distinguishable difference. When you got into length of incarceration, whether execution was ordered, something on more serious, more in-your-face crimes, for lack of a better term, ones people were likely to know about because they were more serious matters that involve that sort of stuff, there was some indication, maybe, like as we saw with the incarceration, but nothing as definitive as with the fines. Did anybody else have any last second questions?
That's right. We have about 3 minutes. Jason, Amy, I also want to give you a chance to respond to anything that Ken had mentioned. I also wanted to just quickly ask, you know, you've done this excellent quantitative analysis. You know, I think Ken's raised some questions and you've raised some issues about what may or may not, you know, what issues there are with that analysis. I'm wondering if you're planning on doing any qualitative analysis in any of the textual records, if they're available. I'm curious to know what may or may not be available to you about, you know, to underpin your findings and just to research more generally about probate courts and how they operated. Do you have plans to do any of that?
In short, yes. When from all these records, she saved every individual case as a PDF so that we could easily go back and analyze the qualitatively the data that was contained therein. So there are some cases that involved a lot more information than others. As we mentioned, a lot of them are just very bare bones. Here's the name of the defendant. Here's what they're charged with. They were guilty. Here's their sentence. And that was it. But in some of the ones that were a little more expansive, yeah, that is something that we would plan to look into, include as a bigger part of, a manuscript that we'd hope to publish at some point on this. Just to give one in particular that I found interesting, to give an example, one of the things we were looking at is what I referred to as crime adjacent cases, things that weren't charged as crimes but easily could have. And then the question being, why not? One of the cases we found, I forget the county off the top of my head, but you had 3 officials that civilly there was a suit brought charging them with bribing or, bribing voters in an election, and the whole election got overturned. It was found that, yeah, there was bribery going on. This got overturned, but it was only dealt with at the civil level, not at the criminal level. And all 3 of the candidates that were brought up in that suit were Mormon. And so the question then becomes, well, why aren't cases like that charged as a crime when they could be? There's essentially a fine bribery. Yeah, there's different levels of proof you have to prove, but those sort of things qualitatively, there's a lot of interesting cases we found that I think would illuminate a little bit of this more. Who's making these decisions? Is it a prosecutor? Was the prosecutor Mormon or not? What was their position in, say, the LDS church hierarchy? That sort of stuff. So yeah, that long answer to a short question, but yes, that is something that we're hoping to look into.
Okay, excellent. Thank you. If there are no other questions, I think that's a good place to stop. I want to thank you, Jason, Amy, for your analysis, for presenting to us. Thank you, Ken, for your comments as well. And thank you all for tuning in. Just a reminder to check out other sessions that we have the rest of this week as part of our conference. This is the last one for today, but tomorrow we have a number of them. And then on Friday will be our keynote address, Dr. Deidre Cooper Owens, on Friday morning that you'll want to tune in for. So thank you very much again.
Thanks, Al.
Thanks for
Thank you,
having
everyone.
us.
Go ahead and end this session. And thanks again, you all, for
Thank you.
for this. I think our recording is going still. Sadie, if you want to turn that off. And then I'll just go ahead and end the session because I think that we're still streaming. So
Cool. Well, thank you. I appreciate you putting this all together and letting us present. That was nice.
It
Thank
was
you.
really fun to be a part of it.
great to hear from you and your work. It's awesome to hear.
Thank you.